This is by the bank pension matter, man. So I just recapitulate what the issue is. What had happened was, man, that the government, the banks, man, decided to give pension. And man, when they decided to give pension, there was a specific provision of revision of pension. There is a revision of pay scales of salaries. There was also a specific provision, regulation 35 is provided that there should be also revision or updation of the pension. Our grievance is, my lord, there has been no updation of the pension since 1992. And my lord, there were continuous representations made to the banks, my lord, banks giving to the associations that we will have updation, which would be at par with RBI and the central government employees, my lord. So what we are seeking is, my lord, not only in terms of the regulation, which is our statutory legal positive right, but also, my lord, emanating out of various copious, my lord, correspondence at the time of, my lord, entering into from CPF, Contributory Provident Fund to pension, that will be giving updation. And, my lord, last time, in an order of this court, my lord had asked them, what is the payment you are making? They have said, they have, my lord, agreed, not in so many words, but the documents which they have produced, that there is no updation, there is only basic pay, rupees 100, and then DA. DA, for DA, there is a separate rule 37. For DA, we have to give, they have to give, my lord. What happens is, my lord, I just give an example, my lord, just to make the controversy, my lord. Suppose it is a basic pay of rupees 100. Then what happens is, my lord, whenever the pay commission report comes or the, my lord, every 5 years they say, my lord, 100 plus DA is 120. 20 is the DA, my lord. Then, my lord, they add 10%. And then when they load into it, then, my lord, it is 10%, so it becomes 132. So, my lord, then the basic, then the, my lord, they start from the next year from 132. Then DA is added. This is how the, my lord, it actually functions. Suppose you don't give, my lord, this updation. What happens? On rupees 100, whatever DA is available. So what is happening is a person who has retired, my lord, is general manager of the bank in 1997, is getting far less than the person who is a clerk or a class member quite below in the rank, who is retiring today. And the problem is, we have also given them all the relevant data which we have culled out from their documents which they have furnished. So how anomalies is taking place. A general manager who retires today gets 1,10,000, but who had retired in the year 2002 or 97 is getting not even 50%. This is the average one. Every rank, my lord, is a 50%. So if there is an updation, then, my lord, we will get a decent wage, my lord, a decent pension, my lord. And, my lord, I just give you the compilation, my lord, and go through that compilation document, my lord, in a try to something new. This is all for this because tell me let's compile it.
But Singla gives.
So Singla, when you started arguing, you said that this pension is being paid out of a fund.
Yes, my lord. Yes, madam.
Doesn't create any burden on the bank.
Yeah, no, madam.
How do you substantiate that argument?
Madam, what has happened is, as on today, the fund in 2025, 31st March.
What is the fund?
4 lakh.
What is the name of the fund?
Fund,
how was it generated?
Pension fund, bank trust fund, madam. I'll just go through that compilation, madam. And it will be clear what the fund is all about, madam. It starts from page 18. 18, my lord, 1-8.
Yes.
My lord, at page 25 is the fund. My lord said, put a query, what is the fund? This is the fund.
Page 18 or
18 is starts.
IoT pension.
Yes.
Page 25?
Page 25.
The fund.
My lord, these are common, my lord. Every bank has more or less the same regulation. The bank shall constitute a fund to be called the Indian Overseas Bank Employees Pension Fund under an irrevocable trust within 120 days from the notified date. My lord, kindly, three is important, my lord. The bank shall be contributed to the fund and shall ensure that the sufficient sums are placed to enable the trustees to make due payments to the beneficiaries under this regulation. Now, my lord, what happens is there is a statutory PF. What happens is, my lord, 10% of the PF amount is transferred to this fund. Now this fund has gone to 4,56,000 in the
CPF. That is under the CPF scheme.
Yes, madam. But now
CPF and pension, they are two different.
No. This is the pension fund. Now 10% is contributed out of the amount of their pension.
From where?
From the contributions which the bank has to make.
Okay.
from the bank they have to make for the employees.
Hmm.
So they contribute in this fund. Fund has three sources. One was the fund which we gave from CPF to PF. Second is what the bank gives, which they have to give in statute anyway. Even if the pension fund is, they have to give that amount. So that amount is now 4,56,000 crores.
For a single bank or for all the banks?
For all the
taken
banks together. Because it will impact all the banks. So we have to take, and Mehta will be paying for all the banks. So I am taking a holistic picture of all the banks. It is 4,56,000 for the biggest corpus, 4,56,000. This year, the rough estimate, it may be 5 lakh crores. The pension which they are giving is only 38,000 crores. And the additional amount which we are asking is only 4,000 crores. 4,000 to 5,000 crores.
The impact of
The impact of the judgment, if we get the updation according to rules and regulations. So it is within the purview, something not we are asking from the government or from whatever the fund is there, we are asking our pool, our money to come back to us. That is the sum and substance of our.
No burden of that. That's
Statute required to give that fund. And banks are also enjoined. Kindly see rule, if they see the fund, if there is a shortfall, the banks are obliged to even provide their funds. They are hardly contributing not even 1% out of that money. So I just go through that. It was 0.33% in the year 2022. Out of this entire, they were hardly 100 crores they were contributing. So the whole idea is that and this money is invested in government securities and interest comes. Interest is also huge. Well, out of this entire amount, it is invested
I
in
have
banks.
no objection. My learned friend can proceed in the manner he wishes. But he should argue from the record. If you take up the, my lord, paper book of ML Singla, that's the appeal on board, my lord. My friend, my lord, is an impleaded party. Lord, he's bringing facts which were not pleaded before the single judge and the division bench. But if
the
a lord said,
statutory provisions he is referring to, sir.
the statutory provision, I
That
have
is
no
what he is
problem.
referring to. He is a part of,
Statutory provision, I have no problem, my lord.
that's what he is reading.
No, my lord. He's bringing facts which are not placed on record about this 4 lakh crore, 38,000 crore. All this is not before the High Court, fellow. I'm not on the statutory provision. Obviously, my lord, statute.
Our petition pending before the Kerala High Court has been transferred, that is received in our bench law. In that we have filed affidavit, in that all this data was given.
So all the data is here, my lord.
Which petition has
Kerala.
No, I'm not aware. Is it on board?
Yes.
It has been transferred, yes.
Lord, I'm not aware of that writ petition which has been transferred.
Item number?
Same item number.
Which bank
So
is it?
there will be some item number to that.
Point 1, 2, 3, 4, 5.
Point 3, 21.3.
I see, my lord. I'm not aware. I'll just have a look at that. Which bank is it?
Transfer petition 2974.
But you have filed account also.
Which bank is involved?
All Kerala Bank Retired Employees Forum.
Oh, I see. I'm not aware of that, my lord.
Yes, ignorance may not be bliss.
My lord, I am appealing for Indian
No,
Bank.
I have no problem. My lord, assist your lordship, my lord. I'm not aware of this petition.
And all these facts have been brought on record. Whatever is I'm stating is already on affidavit, Manoj, and their own. They have also themselves filed affidavit. Some of the facts which I'm mentioning is from their affidavit.
Okay, continue.
My lord, debts have not been transferred, my lord, in this matter, my lord. In 21.3, my lord, I am appearing for Indian Bank, my lord, in this Kerala matter. My lord, debts have not been, my lord, transferred to this honorable court, my lord. Your lordship did not transfer, my lord.
But it is tagged, my lord.
Yes, it is taxed, my lord. It's only a transfer petition, not the writ petition, my lord. Let the transfer was sought, your lordship declined, my lord, to transfer, my lord, the writ petitions.
They've been transferred. That's the question.
No, they have not been.
Manoj, these kind, Manoj.
Anyhow, the lead matter we will hear and the others will be gone by that.
Yes, man.
There is a tagging order on 21st September.
Lord, it was only, Lord, your lordship, Lord, declined to transfer, Lord, only tagged it on their request.
This is the order of declining transfer, sir.
Lord, in the March, Lord, I do not have, Lord, that order, but the lordship, Lord, did not transfer this writ petitions, Lord.
What?
There is no order, Lord, of transferring, Lord.
No, that's a different thing. There is an order of tagging that
No,
as
no,
good as
only,
transfer.
yes, your lordship, blood, they requested your lordship's blood to transfer the writ petitions, but your lordship did not pass any order that
Transfer petition has not been allowed so far according to you.
yes, blood, they have not been allowed, blood.
Very well, very well. Yes, continue, Mr.
Yes, ma'am.
Dr. Singh. Yes.
My lord, kindly, my lord, in this is that the construction of the fund, then my lord, section 7, page 25, my lord, I'll just give the bare idea of the, my lord, relevant points only, my lord. Section 7, regulation 7, composition of the fund,
Yes.
and my lord, the additional annual contribution made by the bank in accordance with the provisions contained in 11 of the regulations. Now, regulation 11 is next, my lord. The bank shall cause an investigation to be made an actuary. My next page, page 26, regulation 11. The bank shall cause an investigation to be made by an actuary into the financial condition of the fund every financial year on 31st March and make such additional annual contribution to the fund as may be required to secure payments of the benefits under the regulations. These are all statutory regulations under section 90 of the banking regulation 1970, my lord. So these are all statutory reports. These are not GOs or government memos, my lord. These are proper statutory regulations and they are judgments to that effect. Now, my lord, kindly turn to regulation 35, which is our, my lord, main sheet anchor. Page 34. Rate of pension. In respect of employees who retired between 1st January 1986 but before 31st October 1987, the basic and additional pension will be updated as per formula given in Appendix 1. Now, my lord, just Appendix
35 clause,
First clause.
clause
Clause
1. I'm sorry.
okay.
In respect of
Again, in respect of employees who retired between 1st January 1986 and 31st October 19, because
Basic pension was your copy,
No, this is, what my friend.
the section 35, it doesn't matter, all right.
what happened was, I'll tell you, my lord. Earlier it was this malware started from 1/11/1987. So therefore they said updation will be from 1/1 versus
You are not getting the copy which you provided.
Copy provided is not accurate. It's not accurate. No, page is there.
The page is
Rate
there.
of pension is also there. Chapter 6 is also there. Page 34.
what had happened was this was amended in 2000.
Whatever, one
So
copy.
this is
One
amended.
copy you have filed an unamended copy, one has an amended copy.
The provision in my copy reads as basic pension and additional pension wherever applicable shall be updated as per the formula
This
given.
was amended in 2003.
But this is the amendment in 2003.
This is the amended provision.
Yes. That's correct. This is not the original one is what my lord Justice Nath has. So that's the original one. Your lordship has the amended one.
So, my lord, what had happened was they amended what I wanted to emphasize was they have amended updation is now not confined to this period of, my lord, 86-87. Now it is as per Appendix 1. Appendix 1 is 4th pay commission was the date time. So the Appendix 1 would be read as 5th pay commission, 6th pay commission, 7th pay commission, whichever comes into force.
Is that page 65 of holders? Page 65.
Appendix 1.
Yes, ma'am.
No.
This provision 35.
All right.
So, my lord, this has been completely ignored by them.
ये हमारे पास तो सही वाला ही है.
ये.
And this is at page 35, my lord. Regulation 37.
Dearness relief.
This is what they are giving. According to the document furnished by them also. I'll just show. Only dearness relief. They are completely effacing regulation 35.
35(1). They are not
35,
following that.
They are not following. Our grievance is, my lord, with regard to that only, my lord.
Dr. Singh, can you read from the High Court judgment where this 35(1) issue has been dealt with?
It has not been dealt with.
No, my lord. Neither before signature nor before division bench.
Was it a ground?
My lord, all that I can say is, my lord, that they primarily relied upon the correspondence which had happened, that updation would be
His
given.
provision was never referred to by the High Court.
It was not.
That's a legal issue.
But my lord, it is a pure legal issue.
Yeah, that's
your only argument.
No, my lord, this is our sheet anchor argument.
All right, let them answer to the sheet anchor argument. If you succeed on this, everything else will be irrelevant.
And because my lord, I have also stated how, my lord, this, my lord, this, at the time of, my lord, I also annexed, at the time when, my lord, this negotiation was taking place, they always said it is going to be updated. So updated was part of that, my lord, exchanges which had happened place, and
What is their stand about updation? The updation is not required.
what they say is, my lord, what they do is now, in the recent, my lord, negotiation which have taken place between England, they say they have relied upon Rule 38 to say it is Rule 35, Regulation 35. I'll just show that also.
How is 38 relevant?
Well, 38 is, my lord, because what happens is that between the date when they apply, my lord, the revised scales, and the date which actually takes place, there is some gap. So how would you compute that gap? For that, this is the refixation of the pay scale with 38 is there. So what they say in the latest affidavit is, my lord, in their affidavit, is they are filed in pursuant to my lord's order, which is the latest affidavit of the IVA, my lord, which is filed in, my lord, this year only by Rajesh on 9.
This point of 35 in your SLP here.
Yes. It's not there in the SLP.
Let them answer.
SLP or any of the writ
So
petitions.
that this is a surprise for you. You are not put to notice on 35.
Lord, it's not that Lord, I can't deal with it. I will deal with it on merit. I'm just saying that the basis of the Lord petition before the single judge and division bench
Doesn't matter.
is an entirely different argument.
Mr. Mehta,
As
we can
I
take
said,
the
Lord, I will
question
answer that. As I said, I will answer
take the
that.
question even now.
I'm only saying this is a new case being set up, but I have no problem. I will deal with it.
And my lord, what they have stated in the affidavit which they have filed here, my lord, because these people, my lord, daily, I am told, my lord, 50 persons are dying daily now. So, my lord, we require.
We understand, but for an adjudication, you have to put the other side to the notice regarding this specific issue of
Yes,
law
my
which you
lord.
are raising.
My lord had put last time order was passed by this honorable court only, my lord, giving them the details which they have filed an affidavit. I read from there only.
Why argument you are raising for the first time?
Yes, but my lord, how they are interpreting 35 is what they want to state, my lord.
All right, tell us.
Yes, my lord. In their affidavit, they have filed in on 19th of February 2026 in pursuant to my lord's order.
Order dated?
My lord. I'll just find it. My lord ordered 5/2/2026. I had asked them because my lord wanted to know whether 35 is implemented or not. So my lord had asked them, how do you calculate the pension? They have given a, my lord, detailed affidavit.
Singla, this doesn't deal with this. Argument is based on an unamended 35. That is the problem. Whatever you have argued on that day, probably refers to unamended.
Unamended also, my lord, amended.
Period of 86 to
Yes, my lord, but no, my lord, amended also serves our purpose more, my lord, because unamended is only for one period. No, my lord, sir, that covered all the periods, 2003, etc. Everything
All right.
is covered.
Okay.
My lord, this order doesn't confine to 87, it goes till 2003.
All right. Now what is their affidavit? Does it
No,
refer to
see
35?
the affidavit, my lord.
Yes.
My lord, if my lord may see the affidavit,
Can you
at
point
page
out
15, only just to say that they are not giving 35 is from page 15.
respond number 5? That is the affidavit. Affidavit on behalf of respondent Punjab National Bank.
Yes, my lord. Yes, my lord.
All right. There
Now-
are 2 pages.
But my lord, there are a lot of documents which are.
Which document do you want to refer to?
Page 15, just to point out how they are giving me the pension and ignoring or completely erasing rule regulation 35. Can you turn to page 15?
Joint note
I think your lordship has another affidavit of Punjab National Bank. My friend is referring to an earlier affidavit which was filed on 19th February, my lord.
2026.
Yeah, that's an application for seeking permission to file additional facts and documents on record filed by Punjab National Bank. That's in
Rajesh Kumar Gautam.
Yes,
Yes, sir.
19th
Yes.
February. I think my friend is...
Yes.
Even details of pension paid to ex-general manager of the bank from so and so.
Yes, my lord. Page 15.
If they update your pension as per 35(1), does it serve your purpose?
Yes. And Mano, formula will be the same as RBI.
All I have written is that
As per the RBI. RBI has already given us to the employees of RBI, we want the same parity. That is.
Can I just, my lord, now briefly, without looking at the papers, my lord, I'll divide my arguments, my lord, in three parts.
yes.
One is the backdrop, my lord. I will give just in a few minutes, my lord. Then the pension regulations, the case set up before the High Court, and the case now set up, my lord. I'll deal with all of that. Now, my lord, historically, my lord, the my lord, the workers' conditions of service in the banking industry, my lord. My lord, the conditions were arrived at by virtue of settlements. My lord, you could recall the Desai Award and the Shastri Award, my lord. These are settlements with the workers under Section 2(3) read with Section 18 of the Industrial Disputes Act, my lord. These working conditions were negotiated by the workers with the banking industry, IBA being the apex body which has all the member banks in it, my lord. Insofar as officers, my lord, are concerned, the officers' regulations, my lord, deal with the conditions of service of the officers, my lord. Prior to, my lord, the pension regulations of 95, there were, my lord, retirement benefits, that is gratuity, and you had the employees, my lord, the contributory fund, that is the employer's contribution, and, my lord, the employer's contribution. There was a demand for, my lord, a second retirement benefit in the form of pension by the, my lord, workers' associations, my lord. So, my lord, discussions took place, my lord, and a memorandum of settlement was arrived at, which, of course, my lord, was the basis of the risk petition, and I will show that, my lord. In the memorandum of settlement, inter alia, it was also mentioned that they will also consider the updation of pension. That's the memorandum of settlement in 1993 prior to the pension regulations, my lord. Now, my lord, so when pension regulations, statutory pension regulations, my lord, came into force on 29th of September 95, what it provided was, my lord, that the officers and the workmen will authorize the bank, my lord, to my lord, transfer the employer's contribution of the provident fund into the pension fund. Without that, my lord, they will not get pension. So all of them had to, my lord, opt. It was an option given, my lord, under the pension regulation. So what if you exercise the option, that, my lord, fund, that employer's contribution will be transferred. So to answer your lordship's question, my lord, this in a sense contributory, unless the central government, my lord, employees, which is, my lord, budgeted.
Part of a CPF.
This is different. This is, my lord, not, my lord, budgeted.
Do
and
your
again,
pension regulations make room for that distinction?
Yes.
You will have to satisfy us on
Yes,
that.
I will do that.
Yes.
So, my lord, options was given, and if whoever opted, my lord, the employer's contribution was transferred to the pension fund, my lord.
All right.
Now, my lord, insofar as, my lord, the issue of, my lord, updation is concerned, 35, which is sought to be relied upon, I will show it is a very delicate compass, and I will explain that, my lord. What is happening is, my lord, and then straight come to the point, my lord, that these settlements which are arrived at are periodical. The settlements with the workers are periodical. So also the officers, my lord, joint note is signed by the officers. In these 4 years, my lord, the workmen, my lord, there are negotiations with the IBA, my lord, which is, my lord, the apex body, which has all the member banks, my lord. So the workmen, my lord, on the one hand, represented by the union, and, my lord, the employees, the banks, my lord, on the other, they have negotiations every, my lord, 4 years, and a settlement is arrived. Similarly, with the officers, my lord, joint note is signed, My lord, for basically revision in, my lord, the allowances, pay, etc. Your lordship is very familiar with that. So this is periodical. So, my lord, therefore, it used to be the Shakti and Desai award. Thereafter, these are the bipartite settlements which are executed every 4 years, my lord, improving the, my lord, terms and conditions of employment of the workmen, and also similarly with the officers by signing out joint notes. The problem arose, my lord, and that is what we've explained in the affidavit. In fact, my lord, I must tell your lordship, they actually represented to the central government also. The central government, after consideration of their representation, has rejected that and it showed that government order also. This government order of the central government was also included in the writ petition filed by them. I'll show the praise in the writ petition. So, my lord, then, my lord, during the pendency of your lordship's, my lord, completed Indian Banks Association, for whom I represent, my lord. Your lordship asked me to consider, the IBA also to consider. IBA has also filed a detailed affidavit which I will show, my lord, why it can't be done, my lord. The statutory, coming back to the statutory regulation now, regulation 35. My lord, if your lordship sees it very carefully, it gives, my lord, it has very limited applicability for certain category of employees. Very, very limited category. And now I'll explain why. Not only the unamended, but also the amended. And the explanation we find on affidavit is this. When these settlements are enforced, now, my lord, your lordship will have to look at the definition of average emoluments and the definition of pay. Because, my lord, ultimately, when you compute pension, you have to look at, my lord, the previous 10 months average emoluments.
Correct.
Now, that is very, very important.
That is only for the purposes of initial determination of the pension.
Correct.
But thereafter, what enhancements will take place on a regular basis is something different.
You have a schedule for that.
No,
along with 35.
No, that's what I'm explaining. It is not for everyone. It is not for everyone.
One minute.
Show that. I'm going to show that, Manoj. And let me first make the point, Manoj. What happens is that they were explaining, Manoj. Let us assume, Manoj, can I first, Manoj, illustrate and then, Manoj, show this, Manoj, if your lordship don't mind. Can I just explain the point, Manoj?
Yes, yes.
Yeah, but the point I'm trying to make is, which is put on affidavit by the bank, my lord, and I will show that also.
Yes.
Supposing, my lord, settlement takes place, my lord, on a person superannuates on 1/1/2024. Correct, my lord? 1/1/2024, a person retires. Now, his average emoluments will be taken.
The last 2 years and 10 months.
Now, supposing, my lord, a settlement is arrived at in September. Now, you have a problem that because, my lord, now there is a settlement intervening which will revise the pay.
That is not an issue also here. No.
I have to, this is the argument dealing with 35. This is the explanation for 35.
First of all, you say whether this 35 regulation applies to them or not.
Not to everyone.
Then who does it apply to? How do you distinguish that?
All right, my lord.
It is a bank employees regulation, pension regulation.
Lord, please, my lord, would you not...
Are officers and clerks separately dealt with by separate regulations?
Let me just explain.
They are all bank employees.
I'm not saying that, my lord.
Yes, then what?
If your lordship has the 10th March 2026 affidavit of the bank, Punjab National.
Why don't we read section 28 first?
I mean,
The regulation 28.
I'm showing one of the regulations. Actually, I find the unamended and amended at one place.
All right.
The lordship has that one.
Very well.
I am sorry, my lord, because we filed this, my lord, this affidavit we're placing. If your lordship has, my lord, the affidavit filed on 10th of March 2026. And permit me to also show the affidavit filed by Indian Banks Association and government's order rejecting the representation. I'll show that also. My lord.
Government is not the employer.
No, it is not. But what I'm saying is they represent it to the central government.
Maybe, that's all right. They are your employees, you have to take care of them.
Now, my lord, if your lordship has the regulations, my lord, page 21. This is the Punjab.
Of your affidavit.
Sorry, my lord, this affidavit on behalf of Punjab National Bank is dated 10th March 2026.
That is same thing titled as application seeking permission to place additional facts.
No, my lord, this is affidavit on behalf of bank, Punjab National Bank. 2-page affidavit.
Yes, all right. We have it now.
That's right, my lord. Now, if your lordship don't mind, can your lordship come to page 21?
Yes.
Pension regulations. Hmm.
My lord, can I just read a few regulations, my lord, so that, my lord, your lordship has a overview. Your lordship has page 21, my lord.
Yes.
Please see, my lord, section 2, small d first, my lord.
Yes. Average emolument.
Emoluments means the average of the pay
Yes.
drawn by an employee during the last 10 months of his service in the bank.
Correct.
So this is my lord how. Now, my lord, pay is defined in 2 small s.
Small s, yes. Pay.
Pay includes in relation to employee who retired who died after the 1st January 86, but before the 1st day of November, the basic pay including stagnation increments, if any, and all allowances counted for the purpose of making contribution to the Provident Fund and for the payment of Dearness allowance. And, my lord, C, B in relation to employees so-and-so, basic pay so-and-so. My lord, there are 4 components. Roman 4 would be the Dearness allowance, my lord, calculated up to so-and-so, so-and-so. Now, pension is defined, my lord, in small t, includes the basic pension and additional pension referred to in chapter 6 of these regulations, my lord.
And you also read the definition of employee also, clause N.
Yes, my lord.
So that,
I'm sorry, my lord, I should have read that. Employee means any person employed in the service on full-time work, on permanent or part-time work, on permanent basis on scale wage, and who opts is governed by these regulations, but does not include a person employed either on contract. That's right.
right.
No problem. I'm grateful, my lord. Now, my lord, the applicability, my lord, to whom it will apply is clause 3, my lord.
Yes.
And your lordship will find clause 3, what I said, my lord, small b, exercise an option.
Yes.
Because then, my lord, they authorize and
Correct.
that transfer takes place, my lord, to the funds.
The contributive fund to transfer to the
Correct.
Provident Fund.
Correct. So that's
Pension
the
fund, yes.
yes.
That event has already happened, there is no dispute.
No dispute. So because, my lord, these are all those who opted. So
Correct.
no problem. But I'm just explaining.
In 1994, before this regulation.
Lord, I myself saying that my friends don't have to interrupt. I'm saying so, my lord. They are those who have opted, obviously, my lord.
Don't unsettle Mr. Mehta. He's already unsettled.
Yeah.
Any questions?
My lord, So, my lord, my friend has raised the constitution of the fund that your lordship will find in chapter 3.
Therefore, Mr. Mehta, we have put you a question
Yes.
whether 35 will apply or not apply.
Yeah, or I come to 35 now.
Come
Let's
to that.
see
And how do you
35.
say that it will apply to class of employees and not to everyone?
Grateful. Let's come to that. My lord,
How?
see page
How do you say
37.
that?
Page
On what
37. Your lordship has 37, my lord.
Yes.
Sorry, page, my lord, 37, but regulation 35.
35, yes.
Now let's read it, my lord. Let's read both clause 1 and clause 2.
Correct.
In respect of employees who retired between 1st January 86.
This is the unamended provision.
I'm just saying I'm going to read both.
Okay.
I'm going to read both.
Very good.
In respect of employees who retired between 1st January 86, but before 31st October 87, basic pension and additional pension will be updated as per the formula given in Appendix 1. That formula, my lord, your lordship will find is at page 57. 57.
Very well.
This form, just a,
1 minute, Dr. Singla, please. Why don't you sit down? Is there a chair available for you? Please take your seat.
So if you look at 56 now, Appendix 1, this applies only in respect of employees, my lord, who retired between 1st January 86 and 31st October 87.
That's what 35 itself says. The unamended 35 said that.
Correct. Now come back to 35 again.
Yes.
Clause 2, my lord, 35(2).
Yes.
In case of an employee, I hope it's legible, my lord, your 35(2). Is it readable, my lord?
Yes.
In the case of an employee retiring in accordance with the provisions of service regulations or settlements after completing qualifying service of not less than 33 years, the amount of basic pension shall be calculated at 50% of the average emolument.
Yes.
There you bring in the average emolument. So, my lord, if you are retiring under the regulation, 33 years of service, your calculation will be at 50% of the average amount. That's why I read, my lord, lord, the definition of average emoluments. But clause 1, my lord, is limited to a certain category of employees, my lord. That is to say, who retired between 1st January 86 but before 31st day of October 87. Correct, my
If
lord?
this classification survive after the amendment, sir, then why you are arguing? The amendment doesn't say that there is any saving clause.
My lordship has not seen the appendix to the amendment. Let me show that.
Yes, let us come to that.
My lord, as I said, let me go step by step. I know, my lord, your lordship is far ahead, but I want to go slow, my lord. As I explained to your lordship, my lord, the justification as to why the banking industry is not because, my lord, we don't want to give to our retired people. The question is, my lord, there is a statutory regime in place, and my lord, several factors and consideration are kept in mind when you frame the regulation, including the funds available. Financial outlay, my lord, the lordships have always said, is a valid consideration for classification.
All right, come to the amended provision
Yes.
and the appendix
Now, if your lordship has page 64, my lord,
64, yes.
now, my lord, this is now the amendment which your lordships were referring to. This is now the amended regulations,
All
correct?
right.
Now, my lord, if your lordship can come to Regulation 35 at page 86.
Page 86.
The lords are page 86, my lord. This is what my lords were inviting my attention to.
Yes,
May I read that, my lord?
yes.
Basic pension and additional pension, wherever applicable, my lord, please mark the words,
Wherever applicable.
wherever applicable, shall be updated as per the formula given in Appendix 1. I will take your lordship to Appendix 1.
Yes.
2 remains the same, my lord. 2 remains the, in the case of the employee retiring,
33 years.
2 remains the same, and the computation has to be. But, my lord, 1 is, can I continue off?
Yes.
Thomas.
As item 28, we are attempting a settlement between the parties. It's an MACT matter. My friend is here. So, Your Lordship, I either posted the Samadhan Samaro, which is coming up in end of August. By then, we'll have something to settle. Perhaps keep this matter in that Samaro. We'll settle it by then.
To settle by then, Nikki by learned counsel for the parties has made a joint request that the settlement talks are in progress, and in case the matter is referred for settlement in the Samadhan Samaro scheduled for 21st, 22nd, 23rd August.
21st, 22nd.
21st, 22nd.
By then, it will come back with.
By then, final settlement could be arrived at.
So I'll just indicate, my lord, we were on Regulation 35, my lord. I was explaining, my lord, the scope and ambit of Regulation 35. After I do that, my lord, after I explain that, I'm going to take your lordships to the affidavit filed by Punjab National Bank explaining the stand, my lord. Also the affidavit filed by IBA, because the lordships had directed IBA to consider their representation. IBA also filed an affidavit, my lord. After that, my lord, I propose to take your lordships to the single judge in the division bench order. And then I have a chart to show, my lord. There's no such dichotomy which my learned friend is pointing out. This is going to be, my lord, the scope of my submissions, my lord. With this backdrop, my lord, now let us go back to 35, my lord. The same affidavit, my lord, which we were reading.
Yes.
Now, your lordship remembers we've read the unamended regulations first, my lord. This is the affidavit of 10th of March 2026.
Correct.
Now, my lord, we saw Regulation 35. Then, my lords, I was going to take your lordships to the amended regulations, which are page 64.
Yes.
Now, page 64, what I showed to your lordship says, my lord, that the amendment in subclause 1, your lordship says that date is removed. That's what fell from the bench, my lord. Your lordship remembers that.
Yes.
Your lordship has page 86, my lord.
86, yes.
Yeah, my lord Justice Mehta has it. Yeah. Now, my lord, basic pension and additional pension, wherever applicable, shall be updated as per the formula given in Appendix 1. So we'll have to go to Appendix 1. 2 remains the same, because as I had explained to your lordships, my lord, for all employees, my lord, if subclause 2 applies, subclause 1 has a limited application under the unamended as well as the amended one. And 38, I had explained to your lordships, my lord, determines, my lord, the date from which, my lord, the 10 months average emoluments will be counted. Have a look at 38 also.
Yes. 10
38
months prior to the date of retirement.
Correct, my lord. From the date of retirement, you go back 10 months. It has some significance. That's why I'm pointing this out, my lord. Now, my lord, because 35(1) requires us to look at Appendix 1, let us look at Appendix 1, page 107, and we will compare it with the previous appendix as well. The previous appendix was at page 57. The present appendix is at page 107.
Yes.
Your lordship will find, now let me read, if your lordship has it, let me read, my lord. The formula for updating basic pension and additional pension in respect of employees who retired between 1/1/86 to 31/10/87 shall be as under. Now, my lord, page 107 and 108 are a copy paste of page 57-58. Let's have a compare it, my lord.
It's the same.
Same, identical.
So why was the appendix not corrected?
I'm coming to that. Now, what is the amendment? What is the addition? Addition is at page 109. Addition is in 109.
Yes.
So 107, 108 captures it from the previous one. Now there is another category introduced in 109. What is that category? If your lordship has close to at top of page 109.
Yes.
The formula for updating basic pension in respect of workmen who have retired on or after 1st day of November 1992, but before the 1st September 1993, and in respect of officers who have retired on or after 1st July 93, but before the 1st day of May 94, shall be as under. So this formula at 109 is again applicable to a limited category of employees who are mentioned in clause 2. So we had, my lord, at 107, a category which was 1/1/86 to 31/10/87. That was one category which was there under the unamended as well as the amended. Now with this amendment, 109, you have another category of those who retired between November 92 and September 93 for workmen, and for officers who retired between 1st July 93 but before 1st day of May 1994. After this, my lord, there have been no amendments, and banks will explain this now in an affidavit which I'll show to your lordship. What is the purpose, my lord, and significance of these dates? I was trying to explain that before, my lord, which is explained in the
And
affidavit.
there is the third category. Many of the petitioners may be falling in the third category as well. Those who retired after 1st November 94, clause 4 of the appendix, page 110.
In respect of employees who have retired on or after 1st November 94 and have drawn special allowance both at the pre-revised and revised rates during the last 10 months of service before retirement, the amount, no, this is not dealing with that aspect. This is dealing with the amount of special allowance.
Tell us what happens to the employees or the officers who have retired after 1st May 1994. How are they to be dealt with?
So that's what I'm pointing out. Banks will explain this. Now, what is the significance as to these categories, which I was trying to explain before lunch also, Manu? You have a situation where these settlements and joint notes are periodically entered into after 4 years, Manu, or 5 years, Manu. And when you enter into, you sign it, but you make it effective from the previous date. I've got a chart which shows, my lord, it is signed on a particular date, but then it's made effective from a previous date. Now, there are situations where large number of employees retire on a particular day, where their last 10 months average emoluments prior to the date of retirement span over 2 settlements. Now, the subsequent settlement will have revised pay scales, etc. So you have a situation where large number of them are retiring, but their, my lord, retirement date is spanning between 2 settlements because the 10 months, 4 months or 5 months may be in the previous settlement, and 4 or 5 months, my lord, 10 months, my lord, 5 months will be in the later settlement. This formula was actually to capture those employees, my lord, only, and not all others who are dealt with under 35(2), read with 38, read with the definition of average emoluments. All of them. And this has been right from 1995. This is the first time, my lord, my learned friends' engineers' argument of bringing in regulation 35, nobody has raised it, my lord. not in the, before the signature, not before, no union had raised it, but for this present application, my lord, which has been moved now before 35, my lord, saying that 35 actually applies to all. It was nobody's case that 35 applies to all. Nobody's case, my lord, before any forum. This now let me explain and then I will take your lordship. So, my lord, let me now show the affidavits and then let me show, my lord, the single judge and the revision bench order. So 38, my lord, is important for the purpose of 10 months of average emoluments. Average emolument definition says last 10 months, my lord, pay is defined, and then, my lord, you come to 35-2, which means you will calculate.
33 years.
Correct, my lord. That's the competition for everybody. But for a limited category, both under the unamended and amended, and thereafter, my lord, what has happened, the affidavit will explain it. Thereafter, no amendments were made. After 2003, insofar as 35 is concerned, there have been other amendments, but not in 35.
What happens to the pay commissions?
No, not.
The effect of pay commissions does not percolate down to these employees.
These are negotiated settlements, the workmen and employees with IBA. All of them, my lord. Officers, joint note, so far as workers are concerned, settlements, bipartite settlements. Every, my lord, 5 years this happens in the industry.
So the effect of pay commissions is not affecting the bank employees' pension or salaries even?
No.
Not even salaries?
Even the revision, the special allowances, DA, everything is negotiated. That's why the single case says, even this pension has come about by virtue of a negotiation and memorandum of settlement between the workmen, officers and the banking industry. The single judge says, why don't you negotiate? That's what the single judge says after rejecting the argument. The entire basis of argument before the single judge was that RBI is giving updation, central government is giving updation, why don't you give updation? And this is, my lord, discrimination. The entire argument was this. Based on, my lord, regulation 56 of the regulation which I will show. That was the entire case, and they relied on clause 12 of the memorandum of settlement, which was precursor to the statutory regulation, which says, Lord, that you will consider the settlement say. But ultimately, this regulations are framed by central government in exercise of power under section 19 of the Banking Act. These are statutory regulations as the previous approval of the central government. Central government says you are not entitled. I will show that, my lord God. IPS said nobody has got it because this doesn't apply to the lord except for that class or category under 35(1). Nobody else, my lord, it is not applicable. It is only applicable to that category. And nobody else has got it. Now, my lord, let me show the affidavits.
So therefore, according to you, even after the amendment in 35(1), the appendix having remained the same,
Yes.
and the period having been crystallized there,
Yes.
86, 87, and then 92, 93, 94, only these categories are entitled and nobody else.
There are all others who are saying
Now, one more question. So the employees covered under 35(1) are not required to complete 33 years. That requirement is not there for them.
33 years will still apply. It's the formula which applies to them. It's only the additional benefit is that the formula will apply because they are retiring, but not this, that 10-month period is spanning in two
So
settlements.
then what happens to employees who retired after 87 and up to 92?
They are all covered by 35(2) rate with 38. All covered. 35(1) is only to, that's what I'm saying. Just have a look at that.
So was there any settlement with respect to this specific period?
Even this, my lord, amendment is by virtue of negotiations. Even this settlement, my lord, as I said, every amendment is by virtue of negotiations. Then, my lord, it is sent to the central government for approval.
petitioners have retired during which period?
My lord, they have retired throughout the period. They are retiring till today, my lord. All our officers and workers.
So what Mr. Mehta says is
My lord.
that your employees, except there are two categories, few who are covered by Appendix 1 for the 2 periods which are provided in Appendix 1, and those who are not covered by the Appendix as per the amended provision even. So their cases would be governed by 35(2) read with 38.
35(2), my lord, kindly read. My lord, this is a complete 35(2) is only for the purposes of average emoluments, how to be deducted. What happens is, my lord, by the time a settlement is made, and the revision takes place on 1st of November of every 5 years, my lord. 1st of November of 22, 17, 12, 7, etc. But the settlement takes place, suppose, my lord, on 24. So between 1st of November 2022, when the effective date is going to take place and the settlement which takes place, it is for to take care of that particular, my lord, that gap.
Correct.
We are not on
That is exactly what is his argument.
We are not on that, my lord. We are not claiming that. That will be governed by persons who are going to retire after 1st of, suppose, my lord, say person has retired on 31st of October 2022.
Therefore, according to him, the updation is only relevant, 35(1) is relevant for those specific periods specified in the appendix.
And there's no challenge to the regulation.
Let us first, 35(2) has a very limited application, both 35(2) and 38. It is with regard to special allowance, average emoluments to be calculated. It has nothing to do with the pension.
No, it is a part of the pension only. Chapter.
Our grievances, my lord, kindly say, our grievances is not with regard to 35(2) at all. Date, updation, it is not updation, my lord. May I say this, my lord, how it happens? My lord, what happens is, I will give you again an example, my lord. A person has retired, my lord, he gets ₹100 at basic pay. My lord, I'll again, my lord, just point out, my lord, what our grievances are, how, my lord, this is a complete tangent with respect, my lord.
Can we read 35(2) again?
Yes, my lord.
Read it.
Yes, my lord. In the case of employee retiring according to provisions of the settlement, qualifying or not less than 0 years, the basic pay shall be as 50% of the average. Very well, my lord.
Correct.
Yes.
So everyone who is not covered by 35(1) will get his pension as per this 35(2).
That is not the point.
1 minute. So that
35(2) is only computation.
that applied part is only for those.
35(2). 35(2) is not.
Again, those employees who are retiring during periods not specified in Appendix 1, they are getting their updations or no?
No.
Nobody is getting it, my lord. I'm sorry. That's what I'm saying. Nobody has complained.
No, the question is whether they are getting any updation, and if so, what is the formula?
So that's what I'm saying. There is no formula for these employees except for this category.
So you don't grant them updation at all?
The idea is, and
So, just please.
yes,
please,
there is no updation.
So all right, one of the employees was getting a pension of 10,000 rupees, say in 2005. So he'll continue to get the same pension?
I'm grateful for the question.
Yes.
Let me now show a chart.
Yes.
Let me show. Your lordship is right. I have to answer that, my lord. I'm very grateful. Give the chart.
Make you copy.
Yes, of course. How can I deprive my friend of copy of the chart?
Don't give him a copy.
I think one copy is extra. Yes, just give that. And I will, my lord, explain by showing the affidavit also how they are compensated by. My lord's question is very valid, my lord. Your lordship is right. Now, if your lordship sees, my lord, I've given different dates because your lordship required us to give different dates in computation. So you will find, my lord, general manager who retires on 30th June 2000. I'm sorry, my lord.
Yes.
Who retires on 30th June 2000. His basic pay, my lord, in 2015, 22 and 26 will remain the same. Okay? Now, my lord, dearness relief will change. Dearness relief will change. The next Gratia, total monthly, commuted, net monthly. So, my lord, the total amount, my lord, will be, my lord, computed on the basis of basic pension, dearness relief, and ex gratia, and then you will get the pension. Now, this is for 2000. Now, similarly for, my lord, retiring the same gentleman, the general manager retiring on 30th of April 2014, you will find basic pension will remain the same. Dearness relief compensates him. That's the statutory scheme, and I will show that. And then, my lord, the total monthly pension of the general manager is like that. Now he compares general manager with a clerk. So let us see about the clerk, which you will find, my lord, at page 3.
How much is
Now, the retirement my lord, first top is manager, so we can skip that and come to clerk. Clerk, that person who retires on 2001, his basic pension is this, his dearness release will be this, and then total net monthly pension will be 34. That is the clerk who retires in 2001. And the clerk who retires in 2014 over page, his basic pension is same, but dearness relief, he gets compensated. This is the statutory scheme. And there's no challenge to my statutory scheme. There's no challenge. There's no challenge to worries of the regulation. This is computation as per the statutory regulations. If you don't mind, I don't understand the chorus, my lord. So, my lord, this kind of, my lord, with great respect and humility, the submission that somebody is getting this obviously depends upon what your pay is. Because when you calculate pension, it depends upon your pay. Now, pay gets revised. If you retire on a subsequent date, your pay may be different. Your pay may be different.
Question here is, Mr. The concept of pension or the dearness allowance, as we understand, with the revisions, ultimately the BA gets merged into the pay. And that's how the basic pay goes up, even for the purposes of pension, calculating pension. What we want to know is to give us a chart of a person who has retired, an employee who has retired in, say, 2022.
Okay.
Right?
Yeah.
So what, or rather 2015. So let us take a period of
I've given
10 years.
2014,
Let us see.
my lord.
2014, let us see.
2014.
So,
I've given
and the pay
2000,
remains the same.
2014.
Basic pay remains the same. It never changes.
Yes. Because it depends upon what your pay is there. That's why I showed the definition.
The question is revision requires a merger. Ultimately, after a particular period, that is what the concept of the pay commission is.
Manoj, pay commission would be.
Yes, we understand that.
Because we have to go by what statutory. That's why I said. Manoj,
You are right.
Let's not import the pay commission into our statutory regulations. It's going to create complication. And it impacts the entire banking industry, Manoj. We have not all the nationalized banks and private banks under one umbrella, Indian Banks Association, who buy projects. It will impact the entire banking industry. So it's not, no point in throwing figures of only 4,000 crores. We don't know whether it's 4,000 or 40,000 crores. We don't know. I don't know how my friend has computed the implication. Because, I
don't know. That's the way, even if it is supposing 100 rupees, but it doesn't fit into the scheme, then they can't get it. Simple as that. So the amount is not relevant. If they are entitled, even if there is no fund with you, you have to pay.
Respectfully bow down to Consultation.
Yes.
So right. My statutory regulation is not under challenge. The entire argument now, let me show from the single judge and the division bench, was completely different. Let me show not the paper book. Complete. Let me show that. Please come back to the paper book of MC Singla.
Sir, Dr. Singla, how do you say that the pay is not being, the pension is not being updated? You were, with this example they have given.
Yes, my lord, kindly
the
see,
particular.
Kindly see this example.
Yes. He was getting 9,841.
A person retires in 2000, his basic pay remains the same.
Basic pay, naturally, which is where is the concept of consolidation? Tell us in the rules.
That is rule 35, updation. Updation is exactly the same. Updation means revision. That is 35. 35 is the
1 minute, Dr. Singla, updation is subject to Appendix A.
Appendix 1.
Appendix 1.
Appendix 1. And what was Appendix 1? Appendix 1 was exact formula which was in the 4th pay commission.
Question here is that appendix is restricted to a particular category of employees or two sets of employees.
Retiring on particular date.
One particular date. 31st October 87. And the second set is,
my lord,
between
92
94. And where is the challenge to that categorization?
No, classification? We are not challenging the regulation because we are claiming rights under the regulation.
No, the appendix. The classification which depends on the
Malot, what we are saying is, Malot, kindly see what my argument is.
You
But
want
Malot,
that appendix to be applied as a whole pan
appendix will be Malot.
across the canvas.
No, Malot, I will take care what happens. This is a statutory regulation, Malot. Appendix also a statute.
Yes.
Correct. Now, Malot, what happens is, at the time when it was inserted, there was fourth pay commission. Malot, fourth pay commission, exact formula which was in the fourth pay commission was in the appendix 1. But they confined it to one category because they wanted to give updation. So updation was always in their mind, otherwise there would have been no updation. Rule 35, there would not have been, because at that point of time only for 1/11/1987 they were getting, so only those period was not getting. Kindly see.
Have you given example of somebody retiring during those the periods specified in Appendix 1 and somebody retiring
I don't think so.
period outside that?
We can do that also.
Get outside there.
So within that period, anyone
understand.
retired, you please give us an example of that.
Yes, I understand, my lord. So 1186 and 1192. Somebody who's retired, my lord, within that period,
During that
somebody who's
period
retired
when you are
outside
applying
that period.
annexure 1, that first clause,
Yes, yes.
those two windows.
I've understood.
In between somebody has retired, you give us
So for that person,
example.
and then somebody who's retired outside that.
The others are all outside
All
that
right,
as per
all
you.
right, all right. I've understood. So for that, my lord, we'll give.
Huh.
Both the dates which
Both
are mentioned
periods,
in there.
and somebody is retiring in the intervening period from 87 to 92 and after
Now it is
94.
computed.
After
For the same post, for the same post.
For the same post.
Yes.
Probably your lordship is asking three charts. One is
Correct.
before, another is after, and one is who's retiring between.
Between.
Three chart we may have to make.
Before we may not need any chart before 87, it's far too remote in time. But during that period,
During that period.
during that period.
During that period.
During 86, 87, then during 87, 92, and then 92, 94, and thereafter 94 onwards.
So, my lord, to whom
Which
it
you
has
have
been
already
given
given.
and to whom it has not been given.
Yes.
Yeah.
My lord, since my lord was asking me the question, my lord, the Dearness allowance is contemplated in
Rules Regulation 37.
Yes.
That's right.
let me, ask me this. So what they are today giving is basic pay plus BA rule 37, regulation 37. He's talking about the statute. I'm talking about the statute also.
Yes.
Now, my lord, 37 is taken care of. We have no problems. 38 is also taken care of whenever there is a gap between the date of settlement and from the revision he has retired, my lord. So that is also taken care of. So, my lord, what we are not getting is 35(1). And 35(1) was first time throughout correspondence updating was part of the settlement. My lord, Mr. Mehta has emphasized settlement. Before we entered into the pension, there are at least 5 letters from the IBA saying that updation would be part on the lines of RBI and central government would be part of the regulations. They were draft regulations also. Therefore, my lord, it was always the case that updation would be part of the, because he has emphasized 10 times about settlement. Settlements are spoken about.
That we understand it refers to annexure appendix 1. Yes.
Substantive provision saying who is entitled for updation.
Yes.
86 to 87.
No, who is entitled, it doesn't say who is entitled. It says
Every pensioner.
wherever applicable.
No, my lord, wherever applicable is
For
where
additional
additional
pension,
pension.
yes.
It is not where pensioners. So wherever additional pension is payable, therefore wherever applicable. Wherever applicable is cannot be expressed. Yes, my lord.
Wherever applicable has a comma before it.
Yes, my lord, very well.
So it is basic pension and additional pension wherever applicable shall be updated as.
Wherever applicable. Pension, my lord, will be applicable to all.
Now,
Yes, sir.
But before 87, this was first paragraph.
We are all pensioners, my lord. We are not claiming any additional pension.
It's a period of 7 days. One is the appendix sub-paragraph. I did it. One after first negotiation, this period was removed. Then the conflict. Yes, it's the appendix A, not on the heading.
Appendix unamended provisions
56.
56.
Yes, my lord. 57, sorry. 57.
Let us see.
It will be taught in here, but not as a subject of which sentence is borrowing the original one. But it has any effect of this period. So what's the period of the problem?
No. The second, the amended appendix has another period added to it, which is not there in the first appendix. The 92 to 94 period is not there in the first appendix under regulation 35.
Yes, yes.
Correct? So therefore, the drafters thought it is better to keep everything in the appendix rather than elaborating or giving all the periods in.
Sorry, we got a second appendix which you got.
Why? The same appendix, amended appendix on page 106, 7. No, beyond that paragraph 3 you read, now that is what Mr. Mehta showed, that the first two pages are the same. First two pages are the same, the third page has an additional time period.
Page 109. Because the appendix specifically provides for two windows. It leaves out the windows in between consciously. So again, when they will calculate, they will not factor in the employees who have retired in between 31/10/87 to 1st of July 1993, or rather 30th June 1993. They will not cover those employees also, or the officers particularly.
Correct, man. Sorry, yeah.
Emolument, not updation, man. But two which are to be added here.
Here,
94. Lot of people are all dearness allowance. It's not updation taken in this.
The formula for updating basic pension in respect of workmen who have retired, that is the updation only. Page 109. You have page 109?
formula for updating, it starts like that only. So that is what.
And this is not part of the first appendix, unamended appendix.
Correct, madam.
Correct?
Yes,
So
madam.
therefore they removed that period so that they could incorporate another.
But madam, no, the main intact fourth pay commission, my lord, that the first two pages remain the same.
That's right, Mr. Mehta said it 3 times.
Correct. My lord, our submission is.
He says because paragraph 2 has been added, therefore the time period has been removed in the amendment.
No, this part which has been there is only to take care of the date of settlement and the date of
And
application.
this amendment is of 2002.
Yes, and after
2003.
2003.
And does not take into consideration anybody retiring after 94 till 2003.
Yeah.
So there has to be some reason why only that specific period was added.
And thereafter there have been no amendments to 35 or
Till today.
till date. And that's the reason I was pointing out. The affidavit will
My lord,
explain all that.
Come to the affidavit.
Yes, I will immediately come to
No, my lord, I will answer that, my lord. Fine.
You answered it
And
later.
then I will take your lordships to the single judge in the division bench order. Now please come back to the affidavit dated 23rd February affidavit. And then I will take your lordships to IBA's affidavit also. My lord, your lordships have
Which is by 10th February का affidavit.
no, this is 23rd February 20, sorry, हाँ, नहीं, 19th February में नहीं, ये वाला जो पढ़ना है. Yeah, my lord, it's IA number 61945, my apologies. It's IA 61945. This application for additional facts. Because your lordships, remember, your lordships order directed us to comply and give calculations.
Serial 29 है sir. मिल गया?
Your lordship has it, my lord?
हाँ.
19th February? Oh, okay.
Yes.
Those calculations which we were asking for, they are provided in this.
Yes, my lord. It's
No,
provided.
that was the order. We don't know whether you provided it or not.
Yes, my lord, we have. We have, my lord. Yes, my lord. Now, before I do that, come to para 4. We explained this, why this categorization, my lord. sorry, my lord, your lordship has it, my lord, page 4 or para 4 of this application. It starts with regard to the submission of the petitioners. That's how it begins, my lord, para 4.
Yes.
My lord, Justice Mehta, is it or not?
Yes.
Yes. You please continue. Yes.
With regard to the submissions of the petitioners,
PDF page 1047.
may I continue?
1 minute.
With regard to the submissions of the petitioners, respondent bank is not making payment to the employees who retired after so and so in terms of Appendix 1. Bank craves leave of this court to make the following submissions. Now, 4.1 and 2, I give the backdrop, my lord, and point out, my lord, regulation
Please
35. Read everything?
Yes.
I'll read it. PNB employees pension regulations are notified in the official gazette on 29 September, made applicable to the employees who retired on or after so and so. However, the pension was paid to the employees who retired on or after 1186 with effect from 1/11/93. Some retrospectivity was given to the regulations, my lord. The Regulation 35 provides for an amount to be paid to employees who have opted for pension due of bank's contribution to the provident fund. 31.5.1 inter provides basic pension and additional pension shall be updated as per the formula given in appendix wherever applicable. Appendix 9 inter provides for a formula for updating basic pension and additional pension in respect to employees who retired between so and so inter for the reason that the pension regulations were notified on so and so. 4.4, 4.5 and 4.6 is important, my lord. It was amended in the year 2002. It was amended in the year 2002 to include the formula for updating basic pension in respect of workmen who have retired on or after 1st November 92, but before the first day of September 93, and in respect of officers who have retired on or after 1st day July, but before 1st day of May 94. That is to arrive, Mr. Singla, if you don't mind, to arrive at the average of 10 months pay for the employees retired during the intervening period of 2 settlement periods, since in such cases, the immediately preceding 10 months time before the date of retirement spanned over 2 bipartite periods, joint note periods. This is the justification. Now I'll continue. This was mentioned to have clarity on the process to be followed to work out the pension for bankers who retired between 1186 date of commencement of pension eligibility and 31/10/87, which is the expiry of 4th bipartite settlement. In each bipartite settlement, a negotiated portion of dearness allowance is merged. For example, in the 4th bipartite, DA of 332 points in CPI was merged. In the 5th, DA of 600 points in CPI was merged. In the 6th, DA of so-and-so points was merged.
What are the dates of these bipartites?
Yes, my lord, I have a chart. I'm grateful, my lord. I'm just going to give a chart for the dates, my lord. Can I just complete the next paragraph and then...
Sure.
Yes. My lord, since the peculiar situation would arise, I'm reading 4.6.
Yes.
At the time of signing of a new bipartite settlement, that some employees will have their 10 months prior to retirement spanning over 2 bipartite periods. In 1998, accordingly, a request was made to the Ministry of Finance to amend the pension calculation method for workmen who retired during the period of 1/11/92 to before 1/9/93, and in respect of officers who retired on or after 1st July 93, but before 1/5/94, as at that time, the effective date of bipartite settlement of workmen and officers were different. The period was prior to the date on which pension regulations became effective, that is 29/9/95. Subsequently, there are no amendments to Regulation 35(1) of Appendix 1 or Appendix 1. However, after each subsequent bipartite, in order to facilitate the calculation of pension for employees whose 10-month period preceding retirement spanned over 2 bipartite settlements joint notes, Indian Banks Association has been issuing letters to the member banks to work out their pension by merging the CPI points agreed in the relevant settlement in which the retirement. So that is why, Manoj, after that 2002, there have been no amendments. IB has been sending letters and bank has been...
Yes, certainly. the subsequent bipartite, to answer that question. Your para 4.5 is restricted or limited to the 6 bipartite.
After that, Your Lordship.
After that, what is the
Yes.
decision on merger?
Where is that mentioned? It's not mentioned in this circular. All right, my lord, we'll give that also. I'll make a note of this.
4.7 you have mentioned in the 11th bipartite, Mr. Mehta.
Yes, yes.
If the similar process has been followed or similar route has been taken, there has to be a merger. Your charts nowhere reflect a merger. It is as simple as that.
Which chart, my lord, is
The
referring to?
chart of this pension which you have provided to us today,
They are yes, sir.
the one which you provided
Yes.
today only,
Yes.
none of the officers have any reflection of merger of DA into their basic pension or basic salary, as the case may be. So if in your subsequent bipartites, when these retirements took place, there is a decision of merger, then obviously they are entitled to that updation. There is no dispute about that now. That is why your affidavit is very craftily drafted. It limits.
We won't do that, my lord, because this is the
Tell
entire.
us if there is a decision of merger subsequent thereto. If there is a merger, obviously you are not paying them as for the bipartite.
We'll also point that out, my lord.
Is that
But after 2010, this problem doesn't exist.
2010? Forget it.
Now we have the NPS system.
No,
after
yes,
pension.
understood.
So this problem now is
Yes.
only for the previous.
So for that period, you tell us all bipartites before 2010
Can you make a note? Lord, we'll make a note of what.
whether there are decisions of merger of DA. Whatever the points may be, the points are differing. As per your para 4.5, that is a consistent practice. It can't be that in the subsequent bipartites there was no decision of merger. It can't be. So the short controversy will boil down to that only: merger or no merger. Because what you are arguing is that they are bound by the bipartite settlements, and if there is no decision of merger, obviously they have to meet that.
So that case is now pinned on 35. The entire case is fixed for 35-1 now.
Irrespective thereof, supposing in the bipartite you have taken a decision of merger, then what happens?
We'll show that.
Yes.
We'll show that also. Now, my lord, your lordship has seen this affidavit. Now let me show the IBS affidavit also, my lord. 4.7 your lordship has seen, my lord. I'm sorry, page 6, 4.7.
Yes.
Now this process, as we've said, is followed, my lord, in the bipartite settlement instead of amending the regulation. That's what we are explaining.
Just 1 minute. There is some error in your already. Your signing is on 95. The date of effect coming into effect is 1992.
Correct, my lord.
3 years prior.
111.93.
Yes, sir. Now, we are giving effect from a back date.
111.93.
92.
Your lordship, why? Because the previous must be the previous period. Is coming to an end.
Yes.
We have to make it effective from
the earlier date.
the earlier date. That's the reason.
Okay.
That's the reason. Now, my lord, come to, my lord, IBS affidavit, then I take the lordship to the single defendant. IBS affidavit, my lord, is filed on 30th September 22. 30th September 22, pursuant to another order passed by your lordship, my lord, directing IBA to consider the short affidavit, my lord. My lord, your lordship has it, my lord? Sorry. This is 13th September 20. Your lordship has it, my lord? First paragraph, my lord, para 2 captures your lordship's order, my lord, asking the committee to be constituted to consider. Then, my lord, para 3 onwards, my lord. After hearing, my lord, this is what, my lord, IBA is pointing out how, my lord, negotiations takes place and the background which I pointed out. Justice Mehta has this affidavit, my lord.
Yes, we are having, don't worry. Yes.
Lord, para 3 onwards, my lord, is what the affidavit is. The committee formed by IBA for the purpose as above discussed all aspects and also heard the representative of various workmen.
Yes.
Workmen unions and officers, and committee has concluded the IBA response sees an association of banks and negotiates with workmen union officers of the member banks on the basis of specific mandate to negotiate in this regard received from such member banks. Service conditions of workmen were governed by JAIIB and Shastri Award as amended thereafter by various bipartisan signs between the banks association on behalf of the member banks, which have provided the force and mandate and various workmen unions from time to time under the provisions of the IB Act, and last such bipartite was signed with so, and thus the service conditions are based on negotiated settlements signed between the parties from time to time. Service condition of officers of various banks are governed by OSR, discipline and appeal regulations, and exercise the power under Section 19 as the case may be. Some of the old private banks who are members of the IBA have also framed identical service regulations in respect of their officers. The aforementioned regulations applicable to officers have also been amended from time to time based on the joint notes signed with the banks, which have been given the mandate to so and so, with the approval of central government as the case may be. The last such joint note has been signed between the parties on 11/11/20. Therefore, terms and conditions of service are statutory in nature, wherein the amendments are made from time to time primarily based on negotiated agreement between the parties, subsequently approved by the respective boards. The pension was not generally prevailing in banks, and that in the bipartite settlement signed with the workmen union on so and so, and joint note signed with the officers association was agreed for the first time between the parties, pension would be introduced as a second retirement benefit in lieu of bank's contribution to provident fund. Said bipartite settlement joint note finally culminating in framing of statutory regulation by the respective member banks, titled as Pension Regulation 95, framed in exercise of power under 19 of the Nationalization Act, with the previous approval of the central government. These pension regulations have been notified on 29 September. Employee officers who opted for pension due of the bank's contribution of PF within the specified period either refunded if already paid or authorized the respective PF trust, if in employment, to transfer the bank's contribution to PF to the respective pension fund. Additionally, contributions were also made to the pension fund by the employees and banks based on actuarial calculation. Hence, the pension fund of the member banks for the payment of pensions have been created by contributions of the bank employees and officers and not from any government grant. The bank employees and officers have been given one benefit of employees provident fund from the employer to get the benefit. The shortfall is the pension fund maintained by the bank is funded by the respective banks based on actuarial calculation from their own revenue. No contribution is made from the government in these pension funds. While the basic pension is fixed at the time of superannuation based on basic pay plus other eligible pay components, the Dearness leave thereon is also given to employees based on the index as applicable to in-service bank employees, updated at semi-annual frequency as per the provisions of BEPRS.
Yes.
May I continue?
Yes.
That so far as pension which is being paid to the central government employees is not paid out of any pension fund created by contribution made by the employees or officers while in service, but treated as a revenue expenditure and paid out of budget allocation. There is no provision in Pension Regulation 95 for any updation in the pension of bank employees and officers. So this is the stand of the IBA, my lord. Their understanding of the regulation is very clear. There is no provision for updation of pension, which is also the finding in the June judgment. Single judge and division bench. There is no provision. Therefore, it would be neither appropriate in principle nor would be financially viable for the banks to accept the representation claim of the employees for updation of pension at par with the central government employees, particularly when there is no parity between two set of employees, central government employees and the bank employees, inter alia for the reason pension in the banks is paid out of pension funds created of bank's contribution to the PF, whereas in respect of central government employees, pension is not paid out of pension fund but is treated as revenue expenditure and paid out of budgetary allocation. In view of the foregoing, it would neither be appropriate nor possible for the banks to consider request of the claim requesting for updation of mention. So this is the IBA's affidavit, my lord. Now, yes, now, my lord, come back to, my lord, the paper book, MC Singla versus Union of India. The government objection. Page 144, Your Lordship, sorry.
Yes.
That's the paper book of MC Singla.
Yes.
That's the SLP paper book.
Yes. Yeah.
Your Lordship has it, main paper book?
Yes.
Yes. Now come to, my Lord, first, the page 144. They represented first, my Lord, before they filed a writ petition. My Lord, nobody has got it, my Lord. For the first time, writ is filed only in 2008.
Yes.
First time. So from 95, nobody understood it. For the first time, they filed it. And the basis is not 35-1. I will show what is the basis of the writ petition. Please see first, page 144.
This is a letter dated 4th January 2005.
January 2005, Government of India, Ministry of Finance, writing to the All India Bank retirees of my Lord, Federation. Subject is updation of pension. I'm so sorry, my Lord, just matter has it.
Yes, please.
I'm directed to refer to your representation dated 17 December on the subject cited above and to say that the matter has been considered by the government and the government agrees with the view of IBA since pension scheme of the public sector banks is based on funding by the banks, unlike the case of government employees, and further the pensioners are compensated with the rise in consumer price index from time to time, there is no case of the updation of post 1/11/87 retirees from the banks. So this is, my Lord, now, my Lord, look at the writ petition and look at the prayer. The writ petition your Lordship will find is at page 145. 145. The case, my Lord, which is set out at page 148, 149 and 150 is the one which was argued before the single judge and the division bench.
Paragraph?
Para 2, page 148.
Yes.
The member of Petitioner Association had been working in PNB in the office of CADA, which posts range from scale 1 to 7. Instead of pension scheme, there used to be contributory fund scheme. By virtue of PNB employees pension scheme was implemented in bank with effect from so-and-so. Said pension scheme was implemented pursuant to memorandum of settlement dated 29/10/93 entered into between the managements of 58 banks represented through IBA Association and the employees of the banks, including workmen staff. It is pertinent to mention, besides the banks, other banks also implemented the pension scheme in pursuance of the Memorandum of Settlement Joint Note of 29/10/93. Relevant extract of memorandum is appended herewith as annexed. Now, clause 12 is what they rely upon. Clause 12 of the settlement, being important, is reproduced below for ready reference, which entirely provides, amongst other provisions, would be made for updating of pension from time to time on the lines in force in the Reserve Bank of India. Clause 12, my Lord, is over the page. Provisions will be made by scheme to be negotiated and settled, please mark the word, between the parties of this settlement by 31st December 93 for applicability, qualifying service, amounts of pension, payment of pension, commutation of pension, family pension, updating and other general conditions, etc. on the lines as are in force in Reserve Bank. This was the clause 12 which is relied upon by them, which was part of the memorandum which preceded the statutory regulation. Now look at para 3. Regulation 56 of the 95 pension regulation is reproduced for ready reference. Residuary provision. In case of doubt in the matter of application of these regulations, regard may be had to the corresponding provision of Central Civil Service Rules 72 or TCS Commutation of Pension Rules 81 applicable for central government employees with such exceptions and modifications as the bank with the previous sanction of the central government may from time to time determine. So, my Lord, if there is a doubt, this is what is to be done. Now, para 4. Cumulative reading of clause 12 of the Memorandum of Settlement and the provisions of Pension Regulation 95 make it clear a specific provision was required to be made. Please note, my Lord. A specific provision was required to be made for updating the pension in consonance with the revision of pay scales granted to serving employees of the bank. But no such provision for updating pension at any stage has been made after enforcement of the scheme, putting the retirees at risk. Their own case was, my Lord, that there is no provision in the statutory regulation, contrary to what has been argued today. pertinent to mention to give effect to the provision of memorandum, a committee of representatives of IBA constituted and a meeting of small committee so and so, which inter alia shows formula for updating pension should be on the lines of reserve bank. And then, my lord, last 8 lines in para 6 at page 150. It is also pertinent to mention, even in subsequent bipartite settlement agreements, this is important, my lord, your lordship may just have that. Para 6, about 10 lines, the sentence begins from, it is also pertinent to mention. It is also pertinent to mention, even in subsequent bipartite settlement agreements, IBA and employees union have not permitted the representations of the union of the retired employees, and as such, no updation in pension could either be considered or made till date, which in fact was required to be done at par with the RBI and central government pension scheme. It clearly speaks of bias and discriminatory attitude of the IBA, bank management, etc. Then, my lord, they say that you please have it in the lines of RBI in para 8. That pertinent to mention pension scheme of bank agreed was to be broadly on the pattern of central government and RBI. RBI has updated it, why are you not doing it? This is the grievance. And, my lord, page para 10 at page 153. That even the representations made to the government for updation of pension have been illegally rejected by the order of 4th January 05, which I just read, inter alia stating pensioners are compensated to the rise of consumer price index from time to time, obviously by granting them dearness allowance. Therefore, there was no cause for updation of pension post 1187 retirement. It is submitted this decision is wholly unjustified and arbitrary on the face of it. When the rise of consumer price index, pay scale of serving employees are revised, and they also get revised dearness pay from time to time, there is no reason to deny this benefit to the retirees on this account. In any case, pension of the retirees is required to be revised at par with the RBI and central government pension scheme, mainly because dearness relief is granted to the retirees on account of rise in consumer price index. Anomaly has not been removed, and rather gap between pension admissible to retirees kept on escalating. And then, my lord, the prayer. Page 158. 158 is the prayer. Roman 2. A writ in the nature of mandamus directing the respondent to update the pension being paid to retirees who retired between 1186 to 31/10/2002 at par with, in consonance with Reserve Bank of India pension scheme and central government pension scheme, and continue to update the pension of the retirees as an ongoing process in accordance with law with retrospective due dates of settlement, and to pay all consequential benefits to the petitioner after removing all the anomalies created against the spirit of the settlement dated 29/10/93. They are not saying that the settlement provides for it. They are saying you are going against the spirit of the 1993 settlement. And, my lord, Roman 3, with the prayer for issuance of writ, quashing the decision of the central government, my lord, and direct, my lord, interim direction, negotiation going on between so and so, so and so. So this is the prayer. Their prayer was that you give us what RBI is giving to its employees, you give us what central government is giving to their employees. But they accept that the statutory regulation doesn't provide for updation. That is the basic premise on the basis of which they went to court. Now, my lord, the single judge order, your lordship will find, is at page 164.
Yes.
Begins from page 167. Your lordship will find 167, the first paragraph, 4th line, where grievance is there has been no updation of the pension in the manner that was contemplated at the time when the pension scheme was introduced. This was pursuant to a settlement between the employees and management on 29/10/93. Now come to page 170, para 4. 170, para 4. The point that has to be examined, para 4, my lord,
Yes.
is whether ex-employees who are governed by pension regulation could seek for application of Reserve Bank of India's regulation or the Central Civil Pension Regulation by reference to the residuary clause in the regulations of the year 95 and the outcome of talks indicating certain proposals between the employees and the management. Petitioner's claim is sourced to clause 12 of the terms of settlement between the bank and the management on 29 September 93 and regulation 56 of the pension regulation. Clause 12 reads, provision will be made by a scheme to be negotiated and settled between the parties of this settlement for applicability, qualifying service, amounts of pension, payment of pension, family pension, updating and other general conditions on the lines as are in force in the Reserve Bank. This clause was one of the terms that the bank had agreed before the scheme was actually brought into force. It shows what the parties had contemplated they would do, including updation and other conditions on the lines that were in force in the Reserve Bank. When the regulations actually were introduced, after further rounds of talks, please note, after further rounds of talks, it only provided through a residuary clause 56 that reads as follows. In case of doubt in the matter, regard be had to the corresponding provision of the CCL rule. After the quotation, my lord, it can be noticed bank regulation was not making any incorporation of either the CCS rules or the Reserve Bank of India pension regulation, mainly provided in the matter of application of these regulations, regard could be had to the provision with such exceptions and modifications when there existed any doubt in the manner of application of these regulations. Regulation 56 could not therefore be treated as making possible certain benefits which Reserve Bank of India's regulation or CCS pension regulation provided for. Petitioners point out to the fact there has been gross prejudice caused by not making periodical updation of pension and would give a tabulation of the disparity amongst the pensions. This is what, my lord, my friend also, Mr. Singla, my lord, pointed out. Then, my lord, para 6, the court refers to the judgment of this court in the Kasturi. DS Nakara is page 173, my lord. My lord, para 7 is another judgment in Union of India versus SPS Vance, my lord. Then, my lord, 175, the court explains, my lord, because Nakara has been explained, my lord, I'll just read para 8, because your lordship has explained in Krishna Kumar and other judgments, my lord, Nakara's principle. Para 8, these two decisions have to be understood in the context of well-known exceptions to Nakara's jurisprudence. The fixation of cut-off date for application of certain pension rules could not be stated to be arbitrary, and between the same class of pensioners, the fact that benefit of increased scale could apply to persons who retired after a particular date is not anathema to law. Different mode of calculation will be impermissible, but there could be sufficient constraining factors like financial outlay, availability of resources for giving certain benefits to be effective from a particular date only, which cannot be made available to all petitioners who retired before that date. Except a situation I have brought out through several decisions of the Supreme Court. My lord, I rely upon especially this judgment of State of West Bengal because it's quite similar to our case, my lord. And permit me to read from here only because the court, my lord, relies upon this. If you see, my lord, page 176 top, where the Honorable Supreme Court was dealing with West Bengal Service Revision of Pay and Allowances Rules of 1990. This was a case where pay scales were revised with effect from a particular date and retirees prior to the date sought for a claim to pension equal to those covered under the revision of pay scale. Referring to the application of principle in DS Nakara, the court, that is this honorable court, held the Constitution bench in Nakara did not strike down the definition of emoluments, nor did it lay down that the same amount of pension must be paid to all persons retiring from government service irrespective of their date of retirement. Nakara decision directed parity in the principle of calculation of pension and not parity in the actual quantum of pension payable. If the formula adopted for computation of pension of all pensioners was the same, namely 50% of the last pay drawn by the incumbent before retirement, the fact those who retired prior to the date of revision of pay scale could not avail themselves of the revised pay scale recommended through the Fourth Pay Commission could not be said to be discriminating. The case of West Bengal presented the following facts which are similar to the case in hand. The pre-86 retirees were not entitled to recalculation of pension on the basis of revised pay scale. Consequently, the formula for calculation of so-and-so retirees, namely 50% of the last pay drawn, though remained the same, actual pay scales themselves did not get periodically upgraded for computation of pension for persons who had retired before 1186. It was in that context that the Supreme Court held, so long as there was homogeneous principle of method of calculation of pension, it could not be stretched as far to seek parity in the actual pension realized irrespective of the date of retirement and the date when the increased scales of pay were made available to pay commission. The same view is expressed in State of Punjab versus Goel, so that is the cutoff date. Then, my lord, your lordship may come to, my lord, 178 para 9. 178 para 9. If we find that Regulation 56 itself cannot be a source for claiming a right at par with the Reserve Bank of India, for claiming a right at par with the Reserve Bank of India employees or the CCS employees. The fact that persons who retired on different dates at different states came by disparity in pension amount, by the fact that increased pay scales were applicable only to persons retired after, but it cannot be said to be discriminating. Petitioners have no right to canvass for what they failed to negotiate and obtain, because as I said, everything was negotiated, even the pension regulation is, my lord, apropos negotiation with the workmen and the officers, my lord. It is set out in the written statement itself. Decision was communicated in the year 2005. Writ petition came to trial more than 3 years and more than 5 years later in this batch of petitions. No explanation is given to the petitioner why petitioner had not immediately approached this court. I am merely stating this in passing. Petitioner could not have come to the court for enforcement and to receive, but they could have pressed for better rights through negotiation in the manner that settlement talks provided. It would be open for the petitioner to make demands for parity if they are so advised and use their bargaining skills through the association press for relief through the mechanism provided under the IDA. Now, my lord, go to the division text. And I will show from the SLP also, my lord, what are the grounds taken in the SLP. Please come to page 5. This was their argument, my lord. Can a set of retired employees claim parity as regards retired benefits with another set of employees of the same rank retiring at a later date by invoking Article 14 of the Constitution? Is the riddle that creates resolution in the instant intra-court appeals brought by retired officers association, so and so. Then, my lord, your lordship will come to para 4 at page 6. You will find the same argument based on clause 12 of the settlement and, my lord, regulation 56. Please just make a note. I won't read it, my lord. Para 4. Clause 12 of the settlement and, my lord, regulation 56 of the pension regulations. Then, my lord, your lordship will find after this submission, my lord, the court refers again to the judgments. I think I can skip that, my lord, because all these Supreme Court judgments are referred to the June judgment, my lord. Then, my lord, I think I can skip, my lord, a lot of quotations from these judgments. And, my lord, you can come to page 24, my lord. Page 24, we can come to 24. Yes. Para 21, my lord.
Yes.
In view of the above, it has been rightly observed by the single judge. Different mode of computation of pension is impermissible, but there could be sufficient constraining factors like financial outlay, availability of resources, making certain benefits to be effective from a particular date, which cannot be made available to all pensioners who retired before that. Appellants in our considered view cannot question the fixation of cut-off date for applicability of pension regulations, as the Supreme Court in so and so held, court should normally not interfere with cut-off dates as there are policy decisions which fall within the domain of the executive authority. Then, my lord, your lordship come to para 22 at page 25. It is not in dispute, unlike budgetary allocation for disbursement of pension to retired government employees, for payment of pension to retired employees of the bank, a fund called the Employees Pension Fund has been constituted out of the contribution by the bank at the rate of 10% per month of the pay of the employee, B, accumulated contributions of the bank to the provident fund and interest accrued thereon up to the date of such transfer in respect of such employees. C, the amount consisting of contributions of the bank along with interest refunded by the employees who had retired before the notified date but who opt for pension in accordance with the provisions contained in the regulation. D, the investment in annuities or securities purchased out of the monies of the fund interest thereon. E, any amount of capital gains arising of capital assets. F, additional annual contribution. G, any income from investment. H, the amount consisting of contribution. The Employees Pension Fund has been created in terms of bipartite settlement arrived
Yes.
I was reading, my lord, page 26, I'm saying.
Yes.
the Employees Pension Fund has been created in terms of bipartite settlement arrived at between IBA and Bank Employees Association, and regulations framed in terms of the settlement do not provide for updation of pension. So this was their own case, and rightly so, my lord. We don't provide for updation. And there is no challenge to the regulation. I can understand if there is a value. There is no value challenge, my lord. Not even here. However, the retired bank employees are being compensated for rise in consumer price index. Even in Nakara, the Supreme Court made a clear distinction that, my lord, we can skip. And then, my lord, at 23 at page 27. Clause 12 of the settlement and regulation 56, in our view, do not advance the case of the appellant. So the entire basis of the fulcrum was clause 12 of regulation 56, which the court doesn't agree. The court, my lord, then sets out, my lord, a single judge's order, and then para 24 at 28, a perusal of clause 12 makes it abundantly clear it only provides for further negotiations as regards applicability, qualifying service, amount of pension, payment of pension, commutation, updating and other judge, and cannot be read to provide for updation of pension. Similarly, regulation 56 deals with a situation where doubt arises in the matter of application of pension scheme and mandates to clear the doubt by referring to the corresponding provision of CCS rules. After the quotation, no such doubt is shown to exist. I could necessitate a reference to corresponding provision of CCS commutation rules applicable for central government employees. Thus, regulation 56 cannot be treated to confer certain benefits upon the appellant, which Reserve Bank of India's regulation or CCS regulation provided for. Clause 17 of the settlement provides, if there is a difference of opinion with regard to the interpretation of any provision of the settlement, the matter can be taken up at the level of IBA and All India Bank Association for discussion and settlement. Presumably, this clause impels the learned single judge to observe it would be open to the appellants to make a demand for parity if they so advise and use their bargaining skills through their association, which they do every 5 years. As been a word about the minutes of meeting of small committee of pension, whereupon it was said to be accepted the formula for updating pension should be on the lines of those given in RBS pension scheme. Discussions held and agreements reached in this meeting, in our view, nothing more than parlays preliminary to the final decision which came in the form of pension scheme of 95. Therefore, the minutes cannot vest the appellant with a right to claim parity with employees of Reserve Bank. It may hastily add that is the specific stand of the respondent to the written statement. Even Reserve Bank of India has withdrawn the order of updation of pension and the matter is pending adjudication. So it was brought to the even RBI has withdrawn. Is what is stated.
We have given it now, man.
Sometimes I'm reading the judgment. Reading the judgment.
You are saying.
Now, my lord, come to the SLP, my lord. Please come to, my lord, page 37, the grounds. There is no whisper of regulation 35 right from the rest to this honorable court. And please look at the grounds. It's clause 12. First ground is clause 12. Second ground is clause 12. Third ground is clause 12. Then, my lord, your lordship will find that ground E. They accept here that there is non-inclusion of provision for updation. They accept there is no provision. In ground E, page 39. They say there is no provision for updation. But they say there should have been one. As per that's ground E. Non-inclusion of provisions of updation of pension was in contravention of the settlement agreement, which was binding on both the parties. This is the case in ground E, page 39. And similarly, my lord, page 40. They rely upon again the draft regulations. They also rely upon the draft regulations. So there's no whisper of regulation 35 anywhere. Single judge division bench, nowhere.
They do bank upon your bipartite settlements. That's right.
Yes, which, as I said, explained further negotiation, and then the statutory regulations have come into force.
After that, there are no bipartite settlements.
Every 5 years.
There are.
Every 5 years.
So now we would like to know.
Yes.
as we pointed out from your own affidavit, that where there has been a merger of the DA. What in the subsequent?
I will explain that.
Because we'll tell you. Come to page 137 of your affidavit. That is PDF 77.
Punjab National Bank's affidavit.
Punjab National Bank's affidavit.
Your
10th March.
That's into the February one?
10th March 26.
10th March. That is the 12th bipartite settlement.
Yes, Manoj.
10th March affidavit.
Page 136. The Lordship is reading 136?
137.
137.
Clause 34.
Yes. Lord, previous clause is also important in 136, which
Yes.
I wanted to read. Clause 2, page 136, and then I'll come to 137. Can I do that, Malak?
Yes.
Very good.
Calculation of pension for employees retired between 1/11/22 and 30th August. As provided in Regulation 35(1), pension payable to employees based on the average of emoluments drawn in the last 10 months preceding the retirement of the employee in terms of Regulation 2, that is 35(2), and 38 of the pension regulation. For the purpose of payment of pension, pay of the employees retiring on or after 1st November 22 will be taken on the basis of pay as provided under the settlement. However, in the case of employees who have retired from the service of the banks on or after 1st November 22, but before 30th August 28, since the period of preceding 10 months will constitute pay both under this settlement as well as pertaining to settlement dated, that is the previous one. In such cases, the following procedure will be adopted for determining pension, which I explained a lot. What was there in appendix, now it forms part of these settlements instead of amending the regulations.
So that's what we say. Now read 34.
34.
Where you have utilized the 100% DA has been utilized. That is merger with effect from November 22, 1st November 22. Where is the effect of that merger in these pension payments?
Can I, your Lordship permit, I just explain.
Yes.
Not this merger of 100%, which your Lordship is talking, not that happens for the serving employees. And this happens.
No, please. Read the heading, para 34. Page 137. Not in service employees, sir. That's why we were asking you for the intervening bipartites.
Lord, I'll explain. Lord, I'll just take instruction. We'll file an affidavit to that effect. That will be
Because
better.
your bipartite clearly says 100% DA merger. Neutralization is merger only.
Yes. Lord, we'll
So
explain.
where
by
is
way
the
of an
effect of
affidavit.
that merger?
I follow.
In
Much
the-
better we put it on
Lord,
affidavit.
Simple as that. Simple as that.
Whatever your Lordship says, we'll put it on affidavit. Lord, that will be better.
Yes.
Because those people will understand better than us.
Correct.
So we'll put it on affidavit. Whatever your
So
Lordship.
in the intervening period, what we read from that paragraph of your affidavit, after the 7th bipartite, subsequent bipartites, how was the merger of DA treated? Right?
Make a note of it.
And here in 12th bipartite, there is a clear established acceptance of 100% utilization of DA, which should be reflected in the pensions post 1st November 22. These are all pre-November 2002 pensioners. So most of the petitioners would be in that category only. Whether this utilization has been reflected in their pension or not.
But just make a note. Have you made a note? We'll do that. We'll give an affidavit to them.
Or else it is your case that no, this bipartite is not to be acted upon, that's a different thing. We don't know. Anything is possible.
No. Why would you not just say that?
Because
I show by the record, I don't
This is-
things outside the record.
that is why we were trying to find out from the intervening period if the bipartites were available. When the earlier ones deal with merger of DA, definitely there would be a merger in the subsequent ones also.
Sure, Lordship will file all affidavit, all the bipartite joint will file everything on record.
From the bipartites,
Only the relevant aspect.
relevant aspects
Yeah.
regarding merger of DA,
Yeah.
wherever it has been done.
We'll do that.
With respect to pensioners.
Pensioners only.
Dealing with pensioners.
We'll do that.
All right, Liche. 1 week.
Manos, I will have to explain.
2 weeks, Manoj.
I will respond to my.
You want to do it right now or after we get the affidavit?
Whatever, my lord. But because my lord, also
One of you argued this, please.
No, my lord, my lord, we are, my lord.
With great respect, with great respect and humility, this, my lord, goes against the procedure, my lord, what your lordship has said. You must lay a foundation, my lord.
You are right. Mr. Mehta, we are dealing with cases of pensioners. We can technically pick the side.
That's why I didn't object.
Yes, we know very fair. We appreciate your fairness to that extent, no doubt.
My lord, when
I gave you that opportunity that if you want, we can frame that question and you can come back with your answer. You said, no, you are ready to argue the matter, we will go here.
That, my lord, is better, my lord. That
No.
he also knows, all the member banks will know that there are implications, my lord.
Yes, certainly.
Because we'll circulate it to all the member banks.
My lord, there is one more request, my lord, that gazette notifications, which they are saying, which 2003, they may be also, my lord, brought on record.
What notification? Why don't you get it? Gazette notifications, Dr. Singh, why do they?
Under the amendment, my lord, we need it. We need it for certain purpose, because
You get a gazette notification.
we don't have, my lord, we have tried.
All right, Mr.
My lord,
Get the gazette notification.
it can come from this library also, my lord. That notification dated 1/3/2003, clause 35 of the bank regulation.
For what? The amendment?
Amendment. Because that was an argument that amendment has only confined to 93.
Sir, I have affidavit, gadget is there.
This gazette is there, you already give a copy to him.
We don't have.
These
We'll
are
respond
not,
to this, my lord. We have something to say on this.
my lord, these are not secrets of the state.
Well, that's why Dr. Singh just needs to spend some time in the library and he'll get it.
Yes.
Nothing.
Yes, ma'am.
Or his associate, whoever it is.
Yes, ma'am.
It's someone who is trying to say something virtually. Rishi. Nageshwar Rao.
Yes.
Yes, my lords, I'm the also retired employee, and I am also interested in outcome of this repetition SLP, my lords. And when I was retired in 1995, the understandings reached between the majority union and the banks are relevant to the consequent pension regulations. I may take you lordships to page number 10, that I have filed an
Mr. Rao, you are not very clearly audible. If you want to address the court, let the other arguments be completed, then you come down here and then address the court. You are hearing matters, it's very difficult to hear virtually. Your voice keeps on breaking. Not very clearly.
It's not audible.
My lord, sir.
I will present, I will present myself.
My lord, let that gazette notification which he has given is of 18 January, it is of 1st of March. So we want that, my lord. That's all we want, my lord. Because we have some appearance. He gave his 18 January.
Notification. What is
Amended by this notification. That is what I have copies.
It says 1st March. That is why the confusion is. That is, there are some apprehensions. It is not that we have.
They will be available online, Dr. Singh.
No, we have tried our level best, my lord.
This is the only gadget, according to us. I'm carrying a copy and 35 amendment is here. I'll put it on the affidavit.
We'll verify it, man, because we have some apprehensions on it.
It's okay.
Mr. Rao,
Mr. Rao, you need to come here and argue physically. You refer to some documents which you are holding. It's difficult to find out those documents here.
No, I have filed an implead application along with it. Along with it, I have filed the application. Page number 2.
Which matter did you file it? There are 3 or 4 matters before us.
3731 and 3736. IA.
That is your IA number in which SLP or which civil appeal?
Yes. 3731 and 3736.
So we are fixing a date after 2 weeks. So you can consider coming down to Delhi and argue your matter in person.
Yes, Mullah. But if it is audible, I can make it this one.
It's not very clearly audible, but
only 5 minutes I will take, Mullah. Nothing more than that.
All right, on the next date when
on the next date we will hear you.
we'll hear you.
Obliged.
So different banks gazetted it on different days.
Must be there.
Maybe because so many nationalized banks.
No, we will see, but we'll verify.
Vijay, counsel for the respondent, Punjab National Bank,
Yes. So IBA can file it also.
IBA,
Huh?
Indian Bank,
PNB will file. PNB.
PNB will file. Punjab National Bank, file an additional affidavit along with additional documents as deliberated upon in the court to list this matter again on today is 22nd. 5th. We wanted 5th August or 12th August?
We'll still be fine.
Whatever is convenient. But
12th
5th is
August.
fine. 12th is fine.
12th August.
But the only thing is, Lordship may formulate the question, my lord. So we will circulate this to all the member banks, my lord, in case somebody wants to represent.
What question you want to be framed?
Regulation 35, my lord.
The respondents would, in particular, respond to the argument advanced by the counsel for the petitioners that the updation as provided under clause 35 of the 1995 regulations, 35(1), Roman 1, bracket 1 kar diyega, of the 1995 regulations as amended in 2002 would apply across board to all the employees, which updation has not been provided in while computing the pensions every year of the retired employees. ठीक?
Seventh onwards, regarding the merger of DA.
Right. The additional affidavit should also contain the bipartite settlements from the 7th bipartite settlement onwards up to 12th bipartite settlement relating to merger of DA while calculating the pension.
And a corresponding joint note, because.
And the corresponding joint note.
They are different. That may be 12, that may be 9 joint notes. So corresponding joint note with the officers.
Corresponding joint note. Very well.
That will be
From
fine.
2002 onwards, fine.
Yes, that is the 7th one.
Till
That
date.
is the eighth one is 2002 only.
Yes, fine.
We'll file the relevant extract, otherwise it'll be too bulky.
It will be bulky.
Yes.
One,
Very well. Relevant extracts of the said bipartite settlements may be filed and not the whole of it. A copy of this entire settlement may be available with the council.
Lordship for you, I'll keep it ready. Except I'll file, otherwise I'll keep the ready goods.
Yes.
well, 5th of August.
12th August.
Lordship.
Obliged.